Right. Okay. Right. Welcome everybody to this webinar, which, although it's a really hot day, it seems like it's a well-attended webinar. Everybody's interested in this subject, Employment Rights Bill. My name is Steve Davis. I'm a current board member, treasurer of the PPMA, and a past president of the PPMA. It's my pleasure to introduce this session, and we've got Hayley Tishner to introduce this subject matter. By the big attendance we got today, it's obviously an important subject that many of you are interested in, wanted to learn a bit more. Hayley's going to talk through a number of slides, and obviously there's quite a lot of content. If you can please put your questions, any questions that you might have as you go along, in the chat. Hayley will try and pick them up as we go along. If not, we can potentially respond to them at a future point. We're allowing a bit extra today, up to 45 minutes today, so we can allow for some questions and that, rather than try and cram it all in half an hour. Okay, so without further ado, I'll hand you over to Hayley.
Brilliant, thanks, Steve. We're just going to try the slides as well as we go through, because I've got Grace behind having a look at the slides as well. So we'll just see, they may just be a little, if there's a little bit of delay, that's the only reason why with the slides. So yeah, afternoon everyone. Thank you for joining this lunchtime webinar on Unpacking the Employment Rights Bill Roadmap, what HR need to know and do. So thanks for that introduction there, Steve. Just so that you're aware, I'm a senior legal advisor at Legal Connect, which is the internal legal division within HR Connect at Commercial Services Group. So I support our education clients and commercial services group with their employment law issues. I've got over 15 years experience in both the public sector, working in-house at Kent County Council, and also in the private sector as well. So I initially wanted to do this session focusing on the changes to unfair dismissal provisions under the Employment Rights Bill, because they were obviously due to come into force next year. However, following the publication of the Employment Rights Bill Roadmap on the 1st of July, I'm instead going to take the opportunity to have a look at the key changes under the roadmap, what these mean for you, what areas or elements you should now be focusing on moving forward as well. So as Steve said, it is a bit of a shorter session today. I have put together some comprehensive slides for you to take away. If we can have time for questions, I will try and take some, but otherwise, like Steve said, if you pop those questions in the chat as we go through, because there's different areas we're going to be talking about. If I don't get a chance to answer anything today, what I will do is answer everything and send that document around to all the attendees. I've also provided my details on the last slide, so don't hesitate to contact me after today's session as well if you've got any follow-up queries as well. So without further ado, let's have a look at the details of the roadmap. So as touched upon on the 1st of July, the government published a roadmap detailing the anticipated timetable for implementing the key measures of the Employment Rights Bill. The roadmap is the first time the government has provided detailed timescales for commencement, and it allows for this staged approach, with measures being implemented in sort of 6 monthly intervals, and which will hopefully provide employers with a little bit more time to prepare for the changes. The roadmap also sets out an anticipated timetable for any necessary consultations as well, and those consultations will be on the detail of those measures that are coming up. Following those consultations, the government will produce a clear and comprehensive guidance to help employers navigate those changes, which is really welcomed. So I've set out here a summary of the proposed timescales on this slide, and we're now going to look at each of those implementation dates. So as we've seen, whilst the majority of the reforms have been staggered over next year and into 2027, some reforms will take effect shortly after the bill is passed into law, and that's anticipated to be in October of this year. We don't actually know the exact date, but like I say, it's around October time. We're hoping that it will receive royal assent. So on this slide here, I've set out some of those measures that will be taking effect on royal assent, and they relate to changes to trade union legislation. Albeit at this first stage, the majority of the changes, as you can see, will involve the repealing of current legislation as opposed to significant implementation. A large proportion of the Employment Rights Bill covers trade unions and collective bargaining, and the bill makes some significant changes to the trade union recognition framework and the ability of unions to take industrial action. And the majority of these changes will be coming in further down the line. So I'm obviously going to take a look at those as we go through the implementation dates. So the first round of changes will come into force in April 2026, and they focus on day one entitlements and broader workplace protections. So we have collective redundancy, the collective redundancy protective award, that is going to be doubled from 90 days gross pay to 180 days gross pay. The changes to collective consultation thresholds will come into force later on, and again, I'm going to touch upon that. This increase from the 90 to 180 days will also apply when you're consulting under a fire and rehire situation. And when you fail to obviously do that process correctly, again, those protective awards will be that 90 to 100 and increasing to 180 days gross pay. Paternity leave and unpaid parental leave. So currently, employees have to be employed for 26 weeks before they are entitled to paternity leave, and employed for 1 year to be eligible for parental leave. That entitlement to paternity and parental leave will become what we call a day one right. So that requirement for that length of service will be completely removed. So because of that, you'll need to update your policies, your handbooks, your contracts of employment in readiness for those changes. You'll also need to be aware of that potential increase in leave requests and from those new employees. And you'll need to consider the potential impact from a resource and finance perspective potentially as well. So whistleblowing, employers who disclose a breach of health and safety obligation or other breach of the law are protected as whistleblowers if they reasonably believe the disclosure is in the public interest. Disclosing sexual harassment will be added to the list of what counts as a qualifying disclosure. Changes to the trade union. So as we said, these have been staged implementation. So at this first stage, you will see implementation of simplifying the trade union recognition process, including the ability for the government to lower the required percentage of trade union members in the bargaining unit to a figure between 2 and 10%. You're also going to get an introduction of electronic and workplace balloting as well. Your Fair Work Agency to be established. So this is an enforcement body which will police compliance with laws such as national minimum wage, modern slavery, and holiday pay. And in the latest amendments to the bill, it's proposed the agency will have some extensive new powers, including enforcing failure to pay certain statutory payments to workers, and also bringing employment tribunal proceedings on behalf of a worker, even if that worker doesn't want to pursue those proceedings. So that can be quite significant. And then arguably, probably the biggest change in this first implementation sector is the statutory sick pay. So the bill will be removing the lower earnings limit, which is currently £123, and that's needed before an individual is entitled to sick pay. There will also be the removal of the 3-day waiting period as well before an individual is entitled to sick pay. So an individual will be entitled to that statutory sick pay on the first day of absence. So it's estimated that around 1.3 million employees are going to benefit from these changes. The government's of the view the changes will reduce the amount of people going to work when they are ill, which they say will then reduce the spread of infections at work, boosting productivity and benefit employers. Sorry, that remains to be seen, I think. So what do the changes to the SSP scheme mean in practice? So every employee, no matter how few hours they work, will now qualify for SSP if they earn anything, and from day one of absence. So a 1 shift a week minimum wage worker earning £98 will still qualify where previously they would not have done. And statutory sick pay will be calculated at 80% of their normal weekly earnings, subject to the SSP cap, which is currently this year £118.75. If you offer enhanced sick pay schemes, which are currently aligned with statutory sick pay, you'll need to reassess that position. For example, those schemes will need to be updated if they're only triggered once statutory sick pay starts, And also more employees, like we said, are now going to qualify. So that might affect how enhanced schemes are budgeted and applied. You might also see the financial impact of short-term absences increasing. So, for example, if you have an employee who has regular instances of absence, they're now going to receive pay for all those days that they're off. So in light of that, you need to consider updating your sickness absence policies now, so you're sort of ready for that implementation. Start monitoring your absence patterns and ensure your return to work processes are robust. Train managers to handle your short-term absence management, capability concerns, and medical referrals with confidence. And maybe even use the opportunity now to review your sick pay policy, ensure that it fits in with your overall employee health, well-being, and absence management strategy. So that's that first stage of implementation. We've then got a second implementation date, which is the 1st of October 2026. And the measures that are going to be implemented here are fire and rehire. So from October next year, it will become automatically unfair to dismiss an employee for not agreeing to a variation to their contract, save only in circumstances where employers can prove serious financial difficulties affecting the business as a going concern. That variation was unavoidable and the process was handled fairly, including proper consultations. The existing ACAS Code of Practice on dismissal and re-engagement, which came into force last year, will be revised in autumn this year to reflect those changes. So whilst that code's awaited, you can look to review that contractual flexibilities that you have in your contracts, avoid including those broad unilateral change clauses that might be in breach of these new provisions. Develop detailed change processes to consult and explore alternatives before any contract variations. Employment tribunal time limit. So again, another big one. So for decades, the deadline has been a 3-month time limit. The Employment Rights Bill is extending that for nearly every employment claim from 3 to 6 months. So this will include your claims for discrimination, your unfair dismissal. So again, in preparation for this change, you should be considering reviewing and extending document retention policies. You might need to hold on to records for at least 9 months after any incident, or maybe longer if that litigation remains possible. And you need to strengthen your internal grievance and appeal processes. With more time now to raise and resolve the issues before claim deadlines, early resolution is going to be likely to become far more viable. Your trade union laws. So again, your second tranche, like I said, of changes to the trade union laws. And what we're going to be seeing here from October is employers will be required to inform new employers of their right to join a trade union, and that should be included in the written statement of employment particulars. Trade union representatives will gain strengthened legal rights to access the workplace, both in person and via virtual platforms. There's going to be strengthened safeguards for those engaged in union activities, including prohibiting of detriments, for example, disciplinary action or pay cuts related to industrial action. And new rights to paid time off for union equality representatives, and with reasonable facilities granted to union representatives as well. Harassment. So you should be aware of the current duty on employers to take reasonable steps to prevent sexual harassment in the workplace. And that came into force in October last year. This is going to be extended. So from October next year, employers are going to be required to take all reasonable steps. So the upshot of that is if you fail to take just one further step, which the tribunal considers to be reasonable, that's going to leave you open to breach of that duty. Now, the government is going to be issuing further regulations on what those steps should be, but what those steps will look like, they're not going to release that until 2027. Significantly, there's also going to be a new obligation on employers to take all reasonable steps to prevent harassment of their employees by third parties. And I just want to take the opportunity to just expand upon that a little bit here. So under the Equality Act, harassment is a form of unlawful discrimination, and an employer is only what we call vicariously liable for the actions of their employees at the moment. So if a colleague harasses another colleague with or without their employer's knowledge, the employer will be vicariously liable for their actions. As it currently stands, an employer is not liable for a third party's actions. So a third party could be a contractor, a client, if you're dealing with education, parents, volunteers, visitors, basically anyone that's not employed by the employer. What the bill does is the bill is imposing direct liability for employers, no matter their size, that if they fail to take all reasonable steps to prevent harassment by third parties on their workforce, they can be held liable. And again, that's that all reasonable steps, so much higher threshold than just the reasonable steps. And significantly, this is in relation to all types of harassment. So we're talking about harassment related to protected characteristics and not just sexual harassment. The moment we sort of don't have any further guidance as to what those steps should look like. And like I've said, the steps in relation to sexual harassment aren't coming in until 2027 anyway. So we have to use previous case law to sort of judge what those steps might look like. And you'll see on this slide here, I've set out 10 sort of steps that I suggest that you sort of consider doing in preparation for this change and the protection from third-party harassment. I'm just going to pull out a couple of these here. So clear anti-harassment policy. So implement and communicate a robust anti-harassment policy that explicitly covers third-party harassment by clients, customers, contractors, or others that aren't employed by the organisation. Training for your employees and managers. So provide training on how to identify, report, and handle third-party harassment. Ensure your managers are aware of their responsibility to protect employees from such behaviour. Consider having contractual clauses with third parties. So where possible, you might be able to include clauses in contract with third parties that hold them accountable for any harassing behaviour, their employees or clients that they might engage in. And then importantly, regular review and risk assessments. Periodically review the workplace environment and conduct risk assessments to identify potential for third-party harassment and adjust those preventative measures accordingly that you might have already put in place. So that's that second tranche. Then the last set of changes will be coming into force during 2027. We don't know the exact dates of when these will come in, but it's going to be definitely in 2027 and throughout that year. And obviously the consultations and the guidance will provide us with more specific dates nearer the time. So the changes we've got here are bereavement leave. So currently, if an employee loses a child under the age of 18, or suffers a stillbirth after 24 weeks, they can take 2 weeks parental bereavement leave. What the bill is introducing is a right to 1 week of unpaid bereavement leave from day one of employment and following the death of a loved one. It's also extending parental bereavement leave to include any pregnancy loss prior to that 24 weeks. So if an individual suffers a miscarriage or an ectopic pregnancy. And again, it's granting that 1 week. Under the bill, though, this 1 week is unpaid. So whilst the provisions for paid leave for your parents who lose a child under 18, or if there is a stillbirth after 24 weeks, that 2-week period will be paid. The introduction of the 1 week bereavement leave for anyone who loses a loved one, or if someone has a miscarriage, will be unpaid. Now, you as employers, you might choose to enhance your policies and maybe give compassionate leave or paid leave. So that's something you can definitely look at, or you might need to align the entitlements to stuff that you currently have in place. So the government's going to consult on those exact durations and the qualifying categories and who will be seen as a loved one. That's likely to be a loss of a parent, a sibling, or a partner. Sexual harassment prevention. So like we've said, whilst that duty to take all reasonable steps to prevent sexual harassment and to prevent third party and protection of third party harassment in relation to all harassment, including the harassment related to protected characteristics, will come into force in October last year. As I touched upon, the details of what those steps must look like isn't going to come into play until the year after, so in relation to 2027. And that will provide some clear sort of guidance and clarity on what those steps will and should sort of be. Rights for pregnant workers and new mothers. So it's going to become unlawful to dismiss a pregnant employee at any point during pregnancy, while on maternity leave, or within 6 months of returning to work. And again, the regulations will set out what specific notices will need to be given to the employee in the event they are dismissed, the evidence the employer will need to produce, and other procedures that will need to be followed. Collective redundancy, and this is introducing in relation to the thresholds. So you remember earlier it was introducing the protective cap award from 90 to 180 days. In 2027, they're now introducing the changes to the threshold. So the duty to collectively consult arises where an employer proposes to dismiss as redundant within 90 days or less 20 or more employees at one establishment. When the bill was published, it made it clear that the duty to collectively consult would apply when the threshold is reached across the whole organisation and not just at a particular establishment. And that would have significant implications for multi-site organisations. In a very significant amendment and possibly the only material concession from the government in favour of employers, the government has proposed that the collective redundancy obligations will be triggered where either 20 or more redundancy hours are proposed at one establishment, or at least the threshold number of employees proposed to be made redundant across the employer's organisation is met. So regulations will set out what that additional threshold will look like. So whether it will be a flat number or a percentage, like 10% of total headcount across the whole of the organisation, which will then trigger that collective consultation. Flexible working rights. So in addition to needing one of the 8 statutory grounds to refuse a flexible working request, any refusal must also be reasonable. Trade unions and industrial actions. So again, we've got some more changes coming in relation to 2027 in relation to trade unions. So we're going to see a comprehensive industrial relations framework will be introduced, setting out clear rules for union employer collective interactions, possibly including a mandated negotiating forum, joint working groups, or sector level fair pay agreements. You're also going to see prohibitions and penalties against employers maintaining or using lists to blacklist individuals for trade union involvement, and they're going to be strengthened. Gender pay and menopause. So employers with at least 250 employees will, as well as publishing yearly gender pay gap figures, will also be required to create and publish equality action plans, addressing how they intend to reduce their gender pay gap and how they are supporting employees going through menopause. So, for example, if they've offered flexible working, workplace adjustments, and signposting to health resources. The plans must be updated at least annually, with details being defined in upcoming regulations as to what that should look like. Enforcement will be via the Equality Human Rights Commission and potentially with penalties or public naming for non-compliance as well. And then finally, and this might be relevant to some of you, they're also going to bring the regulation of umbrella companies. So they will be brought within the definition of employment businesses. Broadly, that is businesses supplying temporary workers, and they're going to be regulated in the same way. And then the 2 significant changes that are coming in play in 2027, the 0 hours and the low hour contracts. So as you're no doubt aware, the bill will be introducing an obligation for employers to offer guaranteed hours to 0 hours and low hour workers if they have worked on average a certain number of hours over a reference period, which we're waiting details on that. And there will also be a mandatory reasonable notice for shifts and changes. There's also going to be compensation for short notice cancellations as well. And the protection will extend to agency workers, with responsibility for offering the guaranteed hours likely falling on the end hirer as opposed to the agency. There's also been some additional amendments that have been made to the bill relating to anti-avoidance measures, and that's following concern that employers may try to manipulate their obligation to make a guaranteed hours offer. And as a result, there will be a right to bring an employment tribunal claim in relation to this. A further amendment to the bill provides that the right to guaranteed hours, to reasonable notice of a shift, and payment for cancellation or change of a shift can be contracted out by a collective agreement between a trade union and an employer. And again, those consultations, we will see the guidance, the more details between how these sort of changes and regulations are going to look in practice. And then lastly, and probably the most significant changes under the bill, is the changes to unfair dismissal. So we're aware that the 2-year qualifying period for bringing unfair dismissal claims is going to be abolished. So individuals will have immediate protection from their first day of work. The regulations will include a statutory initial period of employment. So that will work very much like a probationary period. And that's expected to last around 9 months. But again, we're awaiting regulations to confirm the exact period. And that's going to apply during which employers are allowed to use a sort of lighter touch dismissal procedure. So this light touch process is only going to apply if the reason for dismissal is related to one of the fair reasons for dismissal that we currently have under the Employment Rights Act. So the employee is to do with the employee's conduct or capability, because the employee is subject to a statutory ban, or if there is some other substantial reason related to the employee. And that's really important because it states the reason, like I say, must be related to that employee. So whilst that should include a breakdown in trust and confidence, it doesn't cover a business reorganisation. It doesn't cover non-renewal of a fixed term contract, which means in both those situations, a full fair dismissal process will be needed regardless. So you can't use this light touch process. And that's the same if you're in a redundancy situation as well. So due to these changes, the government estimates 9 million employees are now going to have unfair dismissal rights. So, like I say, we are still awaiting confirmation of the details of the workings of the changes and how that compensation regime may look and change, because there's a suggestion that the compensation for unfair dismissal claims will change as well. Like I say, those consultations and draft regulations are taking place later this year and into next year, and then we're going to have a far better idea of how this is all going to work in practice. Whilst this change now is not going to come into force until 2027 as opposed to next year, given the gravity of the change, it's still going to be beneficial for you, if you haven't all done so already, to have consideration of the following. So start reviewing now how employees are managed during their probationary period and whether your managers are keeping on top of the need to review an employee's performance. Consider reviewing your pre-employment screening process. Ensure your job descriptions are written clearly and the standards expected are known and understood. Ensure your managers fully understand the extended dismissal protections, and that involves, again, that focus on training. So that goes through the employment road, the map as we know it at the moment. Lastly, in this last slide, I just want to look at some key takeaways for you. See if it just scrolled across. Oh, here we go. So looking at those key takeaways. So policies, as we've touched upon, you need to be reviewing your employment contracts, your policies, your procedures to ensure compliance. So like we looked upon, your sickness absence policies, your redundant restructure policies, family rights, sexual harassment, bullying and harassment policies. These will all need to be reviewed along with handbooks and contracts if they're relevant as well. Communicating and engaging with your workforce. So keep employees informed of impending changes. Where appropriate, set up forums to discuss the practicalities. And it's important for employers to listen and address any concerns that are issued. Learning and development. So like I've said throughout this, it's going to be essential to educate senior leadership, line managers, and the wider workforce on the new legal parameters. Some of the legislative changes, if you've seen, are quite complex, and it's going to be really key to ensure that you have training programs that are rolled out effectively. Workforce audits. So the forthcoming changes will require a clear picture of your current workforce. So if you haven't done so already, you should take the opportunity now to gain a clear understanding of how your workforce operates, from policies to procedures to processes to employment status and beyond. What does your workforce look like? Do you use 0-hour contracts? Are agency workers engaged? How many of your employees are flexibly working? And are your employment contracts fit for purpose? Culture. So the importance of workplace culture can't be undervalued in sort of times of transformation. We're entering arguably the most significant period of employment law changing that we've had for decades. So creating that positive workplace culture where employers and employees can navigate the changes together will sort of help minimize those risks. And then lastly, taking part in the consultations. So like I say, many of those consultations have already begun. More will be launched over the next few months. So employers are able to shape that new legislation. You can partake in those consultations, given your perspective on the impact of that on your sector. And so, like I say, keep a lookout for that if you did want to partake in those consultations at all. So, Steve, I don't know if you've got, we've got time, if you've got a couple of questions there. Like I say, any others, do keep including them, or I'm going to put my contact details at the end of the slides so you can contact me directly. But I don't know if there's a couple we can just cover before we finish.
Yeah, we can. Yeah,
John
there
would
was
say.
one question early on, Hayley, about from Lindsay, just checking on the day one rights
Yeah,
for paternity and whether that she assumes it applies to both current and new employees. So I'm assuming anyone with less than um, years service, if you like, can get that. But yeah,
yeah. So it will be when that comes into force. So it will be for employees that are starting when that comes into place. That they then won't be, yeah, that continuous service will then go. There won't be that requirement for that continuous service from them.
yeah, okay. I mean, there's quite a lot in there. I haven't seen any other. I mean, the other questions were just about, yeah, the recording of the webinar
Okay.
and so on and so forth.
Yeah.
As you
Well,
so which we put on our website, so that's fine.
yeah.
Um, yeah, I mean, there's so much in there, and as you say, there's a lot to do in terms of preparation and sort of trying to sort of get policies under review and sort of thinking about
Yeah.
and training.
Yeah,
Um,
there's a lot to sort of, and I don't want individuals to sort of feel burdened by, because there's a lot coming up. There's a lot of changes for people to get their head around. I think the way that we've now got this staggered is better. It's given everyone a little bit of breathing space to sort of understand now what's coming in, when it's coming in, what we sort of need to look to do. I did on the slide there, we have got some training offer, bespoke training that we offer to our clients on some of these changes under the Employment Rights Bill. We've also got a duty to protect sexual harassment toolkit as well, and training webinars. And I will be doing sort of live and pre-recorded webinars on updates on the Employment Rights Bill that again are free. So for everyone to sort of, if they want to join in on those as well, because obviously it's a very much a movable beast. So as we get that more information, as those consultations take place, we can be able to provide updates to everyone as how these changes are going to sort of look in practice. So if people do want to, keep an eye out for that. Like I say, my details, my direct email is on the last slide as well, Steve, for everyone. So like I say, reach out. And I'm more than happy, like I say, we'll have a look at those questions, Steve, and I'm happy to put together a response to disseminate around to everyone as well. And if there's any more questions that come up, please do just, I'm more than happy, just drop me a line. That's absolutely fine.
Great, thank you, Hayley. Just one quick question you might be able to answer quickly. I think this is correct that there will be, so when the 0 hours comes in, and we know there's going to be consultation, but Lee's asked about whether there'd be the opportunity for people to opt out of actually having to have formal hours. So some people really like just that flexibility, don't they, of not
Yeah,
having any kind of
exactly.
fixed hours.
Yeah,
So.
yeah. And like you say, I mean, as with everything with this, we're sort of subject to the final detail. But I get that impression. And when I spoke about in the slide about there being another amendment that came into May on this about having a collective agreement with unions, I think that's sort of that idea as well, that actually you might be able to come to a point where we can agree that maybe it doesn't apply in that way, or we're happy the way it works. So yeah, I think, I mean, obviously, like I say, we're waiting for that more confirmed position, but I think it probably there will be an element of that between parties, because like you say, even sometimes for individuals those 0 hour contracts are beneficial for themselves sometimes, not just sort of the employers. So like I say, keep the biggest takeaways here is really sort of try to look at what you've got in place now. I think the changes coming in and being staged is good, gives you time, but don't sort of get into a false sense of security that, oh, we've got ages now, because you can see they're quite significant. You need to sort of get your head around them. You need to make sure your policies are updated, your training to make sure everyone's sort of on board with them. So just keep up to date as you can with the consultations. Like I say, if you want to access ours or any other resources you have, just to keep up to date as to what those consultations, what more definitive position we know in relation to each of the changes that are coming into force.
Great. Thank
Okay,
you, Hayley. That's really good. Thank you.
no
And
worries.
yeah,
Thank you. And I
a
hope
few
everyone's
thank
found that
yous,
useful.
in there now.
Brilliant.
Yeah, lots of hands up and thumbs up and all that. So, okay. That's great. Thank
Okay,
you very much.
thank you. Thanks everyone for listening.
Cheers.